My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In this installment of Scales, or Suwannee County Access to Legal Education series, I'm going to be discussing the calculation of child support. Now, the calculation of child support is simply a mathematical formula that's governed by Florida Statute 61.30. The statute defines some important terms, and then the case law provides authority under certain scenarios, such as when the child is receiving a derivative benefit from one parent who receives Social Security. So first, the court needs to know the income of the parties. Income is defined in Statute 61.30. Income includes but is not limited to salary, wages, bonuses, workers' comp, disability payments, reimbursed or in-kind payments that reduce living expenses, and quite a few other things. You can look up the statute to see the entire list. Now, income may be imputed to a party under certain circumstances, such as when somebody is voluntarily unemployed or underemployed, or someone that fails to participate altogether in the proceedings. The court has a 5-year look-back period to see what your average income usually is. Now, there are certain things that are deducted from income, and deductions make logical sense because they are generally things that are beyond the person's control, such as federal and state taxes, mandatory union dues, mandatory retirement payments, health insurance payments for the individual, and prior court-ordered child support payments, but only if the child support obligation is actually being paid. Other factors that the court will take into consideration in calculating child support is the percentage of overnights with each parent. If the obligor parent, or the person who is paying the child support, has 20% or greater of the overnights, there is a different calculation that is used. It's called the gross-up method. And in general, the more overnights the obligor parent has, then the lower the child support obligation will be. The court may deviate from the child support guidelines by up to 5% without making any written findings, but anything greater than 5% deviation is going to require the court to give the reasons why, which is called the written findings. But what if the child is receiving a derivative benefit from Social Security due to a parent's disability? Now, that does not mean that there is no child support obligation for the parent getting disability, but there's a specific way to calculate the child support. And in general, the derivative benefit is going to reduce the obligor's obligation. But in the situation where the derivative benefit is higher than what the child support calculates out to, then the obligor is not going to have to pay any additional child support. If you found this information useful, or you know someone who could benefit from it, please like and share. And follow the campaign's social media. Do you have a particular topic you'd like me to address? Well, send the campaign a message through social media or the website. I'd be happy to film a video on your topic, but just remember that I can't talk about a specific case. If you ever miss an installment of Scales, visit the campaign website to see all of the Scales videos. That's where they're being archived. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.